So, good news, Beverly has been able to arrive, and that means that our CLE will be beginning. Beverly, I have made you a co-host.
Excellent.
So, hey, we do start out with two questions. I don't know when you would like them, but I'm happy to ask them now.
Yeah, go ahead and ask them now, and then I'll pull up the PowerPoint. And my apologies, everyone. I was on the record in Thurston County via Zoom, and we just wrapped up. So,
Okay, so actually, I take that back. One of the questions is for myself, and one is for you. The
okay.
question for you is, this may be covered, but are you doing any CIR work related to probates and that possible intersection of law?
That will be covered. Yes. So, and remind me to bring up how that interacts at the end of this presentation. Okay.
Okay.
All
And
right.
then just real fast, the other one, yes, the CLE materials are available in the law library. Okay, I am
Okay.
done.
Okay, welcome everyone. My name is Beverly Allen. I've been practicing family law, fully licensed for going on 16 years now, and 17 if you count the Rule 9, which of course I do. For those of you who don't know me, I've been mostly practicing in the Pierce County area throughout my practice. Most of that has been solo. I do have a Rule 9 as well that you might see occasionally. She's taking the bar exam this month, Ann Dorn. And also, if you happen to know any associates who want to join a family law practice, or if you're looking for a referral relationship, things are very busy for my practice at the moment. So I would love either. But getting to and what we're going to cover. So first, we're going to be talking about committed intimate relationships. And the definition here is on the screen. That's going to be repeated in some of these cases that we're going to discuss. But essentially, a committed intimate relationship, it's a creature of common law. It has evolved over the decades, really going back to the 40s, as you'll see in some of the later slides. So lots of history over what a committed intimate relationship is. And there are some important notes for this. Namely, there's a built-in statute of limitations, which is 3 years from the termination of the relationship. The committed intimate relationship may be beneficial to your clients. It might also be detrimental to your client. It may be beneficial if there is quasi-community property, which is property that if there were a marriage, it would be considered community property. And it may be detrimental to your client if there is a lot of debt that your client is trying to avoid as well. So with all of this, you'll want to consider whether or not to even file for one, because there may be other ways to handle the distribution of property, or you might be simply too late to file a committed intimate relationship. All right, so if there is no committed intimate relationship, either because the relationship appears particularly unstable, or more commonly, or just as commonly, it's been more than 3 years since the end of the relationship, there are other options, particularly when real property is at issue. And the main option we're going to be talking about today is a partition, which is in theory, the court could order that the real property is simply sliced up or divided. That never happens. So in practice, partition is about forcing a sale and dividing up the equity. And it may be beneficial if the client is trying to protect what could be a quasi-community asset. It could be beneficial if the client is trying to get out of having to share some of what would be debt as well. Or if, let's say, a committed intimate relationship is an option, but a partition would give your client a bigger slice of the equity because they've simply contributed more to that asset, a partition may also be the way to go. All right. So we have a little roadmap. We're going to be talking about the foundations, establishing and litigating a committed intimate relationship, some of the limits of the doctrine. We'll also talk about partition and other remedies, including, and this touches a little bit on the question, the Uniform Partition of Heirs Property Act, which is a relatively new statute. Okay, but getting into so common law marriage. Uh, Most lay people understand that term. Common law marriage is generally, if you've been living together and sharing property, you are deemed married, essentially for purposes of states that recognize common law marriage. Now, this case, marriage of Pennington, it came out in 2000. And it's the one that we covered in my particular family law class, taught by Julie Shapiro, rest in peace, Seattle University School of Law. And my initial impressions of the Pennington case when I read it, and going really into up until Murden versus Rettle, so we'll get into the history of that, was that committed intimate relationships are far more strict than marriages, at least in terms of the conduct of the behavior expected of both parties. Prior to Murden versus Rettle, um, initially, I was of the impression that things like affairs or lack of sexual intimacy may defeat a committed intimate relationship claim. And certainly the courts have seen those different arguments play out. Also, the duration of the committed intimate relationship, while that is a factor, it is not necessarily determinative. So there are certainly challenges to committed intimate relationships. The court's findings are going to be reviewed under an abuse of discretion standard, but Pennington really wanted to make it clear that there's a difference between common law marriage and committed intimate relationships. In many ways, they're very similar, and as you're advising your clients, you may find yourself referring to common law marriage by way of analogy because they simply understand they do understand that committed intimate relationships are a bit more tricky. So they are judicially created equitable doctrine to reserve property distribution when marital-like relationships end. That public policy has been repeated in several cases, Ambergy versus Volk, and then also Connell and Francisco. So this is equitable relief only. Again, it does not create a marital status, nor does it create any statutory rights, or nor are there statutory rights that underlie. So a little bit of history. As I mentioned earlier, we are starting really from 1948 with the Creasman presumption. And as many of us know when we're advising our clients, the concept of title is definitely something that looms large in the popular imagination. So many times our clients believe that the title controls. And at one point, the state of Washington agreed with them. That was known as the Creasman principle, that the party was presumed to belong to the parties in whose name it was placed. That was overturned in 1984 by the case of marriage of Lindsay, and the courts really examined the whole relationship and apply equitable principles. So that's where, now we advise clients that what matters is when the property was acquired, the source of money that was used to acquire the property. Those things really determine whether it's community in nature, or in the case of a committed intimate relationship, they use the term quasi-community, but it's treated much the same. And in 1995, Connell versus Francisco solidified that concept that property acquired during the relationship is going to be presumed to be jointly owned. Pennington, as I've already mentioned, so that did refine the multi-factor test, and importantly, it affirmed that Washington has no common law marriage. So Oliver versus Fowler, that case is on here because that's where we really shifted the terms of how we talk about these relationships. You will still find older case law that refers to committed intimate relationships as meretricious relationships. Really, that has the same energy as stating that a child was born out of wedlock. It's antiquated, it's old-fashioned. We're no longer using it. But the doctrine does survive the death of one or more partners. So this does come up in litigation and probate litigation. Uh, the idea is that the decedent, if they were in a committed intimate relationship and that is acknowledged by the court, there would be some community property that their surviving partner would be entitled to. All right, so these are the factors. And again, just overall, what the court is looking for is a stable marital-like relationship where both parties cohabitated with the full knowledge that a lawful marriage between them does not exist. So the factors that the court is looking for, and again, they're not necessarily, they're not weighted, at least not in the common law. They have to be considered. And then, of course, the court's ultimate determination is reviewable under the abuse of discretion standard. So we're looking for a continuous cohabitation, the duration of the relationship. I've seen committed intimate relationships be as little as 4 years. I think if it were too brief, it would not meet the standard. But again, what's too brief? That is going to be in the opinion of the court and based on the evidence. The purpose of the relationship, that's an interesting one. Some of the case law looks at whether or not this is really a spouse or whether they're a paid caregiver. And if they're a paid caregiver, they're not a spouse. But if the purpose is for love and affection, then that would be a valid a valid marital-like relationship and purpose. Pooling of resources for joint ventures and then intent of the parties. Those are also factors that come up and are the source of a lot of litigation. Does every account need to be shared? Probably not. Does there need to be a general agreement for how things are paid for? Um, yes. And are both partners expected to contribute to that? Probably. But again, these are very fact-specific cases. Intent of the parties, generally pregnancy, childbirth, during the committed intimate relationship is going to be pretty dispositive of the intent of the parties. Also, although this isn't a specific factor on the list, I find that terms that the parties use to refer to each other, for example, hubby, wifey, husband, wife, spouse, those types of terms provide some pretty good evidence to the community at large for how this couple understood themselves. Now, it used to be that there still is no pattern form for this, but for those of you who do purchase software that assists with drafting forms, you may find that your software does have a committed intimate relationship complaint, a complaint for the dissolution of that. Now, you would want to specify within that complaint if one of the parties to that relationship is deceased, so that the court understands that. But in terms of what, if you're looking for a sample, the software that I use is called My Pleadings. And the sample that is created there does have a lot of these factors fleshed out by way of examples. And so it is a very useful template. Prior to the development of that template, what attorneys were doing is simply drafting a complaint and doing their best to demonstrate these factors within the complaint. And then, of course, the response. It was also something of a design your own response to that, but modeled very closely off of the existing pattern forms. As of today, though, there exist no pattern forms because, of course, it's not a statutory creature. All right, so I do want to touch on a little bit of some of the history with the registered domestic partnerships. Because that is something that is still today available if there's a partner that is 62 years or older. But some of the public policy and equitable doctrines that drive a committed intimate relationship were also present in the marriage equality discussions, and the statutory status that was created for same-sex couples prior to marriage equality passing. And like I said, it does survive in a very limited form if there's a partner that is 62 years or older. The registered domestic partnership status for same-sex couples, those were automatically converted into marriage. And on June 30th, 2014, it has been a while. So I doubt that's coming up for folks, although I'd be really interested if today in 2026, there was a story about someone who wasn't aware that they had been legally converted to marriage and needed to get a divorce. That would be interesting if that's still cropping up. So, in common law marriage, again, that's not something we have in Washington, but with the five-factor test and with the right proof, you can establish a committed intimate relationship. And then, of course, the legacy labels of meretricious relationship or equity relationship have been retired, but some of the doctrinal underpinnings or the public policy and equitable underpinnings are still present, even if you're looking at those older cases with that antiquated language. All right, so there may be different hybrid timelines. For example, if someone was registering, well, if someone registered for a domestic partnership, then that converted their marriage, but they might have had a committed intimate relationship earlier on in their relationship. And in fact, as we're drafting the divorce petitions, it's not uncommon for us to be arguing in court that the time prior to the marriage met the criteria for a committed intimate relationship. It does, of course, ask that in the pattern forms developed by AOC, the Administrative Office of the Courts, which we're required to use. It came up in one of my cases with respect to a house. It's usually a house that is driving the committed intimate relationship doctrine. And in that particular case, the parties did end up married, but the question and the fight in court was, were they in a committed intimate relationship at the time that my client had purchased the house? Ultimately, the court decided no, and then had to consider whether there was an appropriate marital lien, which a marital lien is also an equitable creation rather. And essentially, if the community is paying into even a separate asset under a committed intimate relationship, is the community owed something in return? And how does the court deal with that? So I will revisit that at a later point. And then, of course, if I don't, I'm making myself a note to revisit the equitable lien. All right, so Connell versus Francisco, as if you recall from the earlier slide, is an important piece of establishing this community property-like presumption. And Connell versus Francisco also distinguishes between property that would be separate if it were a marriage and property that would be presumed community if this were a marriage, and directs the court to treat the nature of the property, if it's quasi-community, as divisible, and then, of course, prohibits the court from dividing separate property within a committed intimate relationship. So only the property that would be a presumptively joint property is available to the court for a just and equitable distribution. So what does that mean in practice? Well, that means that if the property was acquired from an inheritance, it can be argued that that is separate property. Again, subject to a community property lien, which could be argued, especially if community or quasi-community like assets were spent to improve or maintain that property. But again, Connell does refer back to the Creasman presumption, and although the average person on the street may not be aware that title is not dispositive. Attorneys in the courts know, and Connell does reiterate that title in one party's name does not itself rebut the presumption of common ownership. So if it would be separate, it's not before the court. If it would be community, it is before the court. And that's where a lot of the fights are in terms of the evidence and the actual trial practice. Okay, so here are some examples of what can support a CIR and what can defeat a CIR. My favorite example was an email where one of the partners was referring to the other partner as her hubby and was, in fact, trying to promote his business. That was a key piece of evidence in one of my cases where I established a committed intimate relationship. But some of the examples here, again, this is just going back to the factors. But if you have continuous cohabitation as a family household and you have that over several years, this says many years, but again, it could be as little as, I would say, 4. Anything below that, I think you're going to have a difficult time, but not impossible. And then anything above that, I think you're fairly safe just based on the number of years that I've looked at. Murden versus Rettle, for example, um, was a case where there were not all that many years of cohabitation from my memory. Raising children together, again, that's a big one. The court, when it looks at what's the purpose of the relationship, whether it's similar to a marriage, whether it's marital-like, having children and raising children together is a big factor. Adoptions, and this is especially true where you have a same-sex couple, but if there have been adoptions of the other partner's child or children, that would also support that this is a marital-like relationship and that the partners, one of the purposes is to raise a family together. Pooled accounts, again, I don't think every account has to be pooled. I do think that there has to be at least a plan in place that was agreed to or implemented and consented to for how to pay the bills for the household. Shared projects, that could be things like home improvements, which also factors into whether or not there's an equitable lien, even if there wasn't a committed intimate relationship. And that would be something that would come up if there was a later marriage, as in the example that I gave from one of my own trials. So holding out as a couple, caring for one another in illness. In the form that my pleadings has prepared as a template for a complaint to end a committed intimate relationship, it focuses on what the evidence is that each geographic community knew this party as a couple. So, for example, was the couple going, to church or participating in civic life, the PTA, and holding themselves as a couple for different communities? And then that would be very important information to flesh out as well. It's great if you can find a witness that wasn't even aware that the parties were not married and then suddenly learns of that at around the time of the litigation. That's pretty strong evidence that they were holding themselves out as if they were a marital couple. And as I mentioned earlier, the case of Murden versus Rettle had 2 things going on. It had a cessation of sexual intimacy, and it also had other romantic partners that were that had cropped up throughout the relationship. That alone did not defeat the committed intimate relationship. And, in reality, a lot of our cases where the parties are married, there are issues like lack of sexual intimacy, and there are issues such as other partners. So it makes sense that the doctrine on committed intimate relationships would start to acknowledge that. Immigration practice also, to my understanding, I don't practice immigration, but for my fellow colleagues who do, they've assured me that some of these arguments in terms of whether the marriage is a legitimate marriage or not refer to arrangements that legally married people enjoy, and that can be a way to convince the court that your parties are in fact legitimately married because look at what, divorcing couples and that are recognized as being legitimately married, what kinds of activities they engage in. They're still married. So the evidence defeating a committed intimate relationship. So sporadic cohabitation and no shared social life, that came up in this Henry Kelly case. That was a 2012 case. There are interesting cases where there are periods of moving out and then moving back in. And I think so. How I've used that in my litigation and how I've seen it come up is whether or not that defeats the overall stability of the relationship when looked at as a whole. And if the periods of cohabitation are infrequent, if they're shorter, if it's moving in, moving out, it seems like a roommate situation, then I think that would defeat a committed intimate relationship. As far as the shared social life, that has to do with as well how the community really understands this couple. If the couple is not, ever seen together at birthday parties, family events, important community events, then that's evidence that they may not be a committed intimate relationship, that they may not be holding themselves out as a married couple. But again, it's case by case specific, and there are plenty of formally legally married couples that don't necessarily have a shared social life. Um, Deliberately separate finances and no pooling or joint ventures at all. So that is an interesting one that comes up, and I think would be important for trying to defeat a committed intimate relationship. Of course, this can also be worked out, and if you're advising a client who is wanting to protect themselves and protect a specific asset, I would advise on negotiating a cohabitation agreement and really specifying that it's usually the house, that the house and say retirement accounts are in fact separate. So there are protections that you can and should advise your clients to take in the event that they are in a long-term relationship, but they're never planning on getting married. Well, they can still find themselves in a process that looks an awful lot like divorce, maybe worse in some cases than a divorce trial, even if they don't formally tie the knot. So if it's a relationship of convenience, and that's where some of the arguments, especially around joint pooling, come up, that this is a roommate only situation, friends with benefits only situation, just a girlfriend, just a boyfriend, that it's not permanent, it's not long term. It's just because they needed someone with a good credit score to co-sign on the apartment lease, something like that. So that would potentially defeat a committed intimate relationship. And then no holding out, no intent to form a marital-like relationship. Um, so again, that's kind of how the community understands this couple. So if this couple was not holding themselves out to be a committed marital-like relationship, if they didn't use those pet terms for each other, if they indicated that it was a casual thing, a roommate thing, that there's no sort of sense of commitment between those two people, then that could defeat a committed intimate relationship. Okay. So in terms of the start and ending dates, again, the committed intimate relationship window, there is a 3-year statute of limitations that the court recognizes that. And when the relationship is over is determinative onto when that statute of limitations period starts. And that is a equitable created case law statute of limitations, because again, this isn't a statutory issue, but it borrows from that. And 3 years is the recognized statute of limitations. So I've seen motions to dismiss be granted. I've advised clients that they're outside that window if the relationship is over. So this is also where some of the litigation comes into play is, well, when is it over? Now, there was a case of GFW where that question was raised, and the holding of the court is that a party had to unequivocally express the intent to end the relationship for it to be over. So even if the parties were still sharing a residence, if there hadn't been that unequivocal expression of the relationship is over, potentially that might not toll the statute of limitation. Again, this is going to be case specific and evidence specific. Um, let's see. And in the Walsh versus Reynolds litigation, the yeah, that question of when it started was also very important, and that can scoop up under Connell many more years of community property or community debt. So, as far as a practice point, we're looking at evidence, things like opening up bank accounts, things like when leases were signed, sometimes text messages, eyewitness accounts, anything you can do to really flesh out that timeline is going to be very important for the court because it would drive the limitations defense, and that it also affects the characterization and the valuation of what is considered to be that quasi-community property or debt. Okay, so I mentioned that the statute of limitations was created by a case, and this is the case, Kelly. It was a 2012 case, and so a party must sue to establish that the relationship existed within 3 years of the end of the relationship. If it's been missed, there are still options for dividing up that real property that may have been acquired. But again, that may be a partition action to provide some remedy to a former co-tenant to recover some of the value of the property. All right, so in terms of the presumption that property acquired within a committed intimate relationship is community, that can be rebutted. And once it's established, though, the burden would shift to the party claiming that the property is separate to rebut that presumption. So I already mentioned tracing acquisition to separate funds or pre-relationship property because, and this comes up in our divorce cases as well. If the source of the funds that acquired a specific asset are separate, then the asset itself could also be or would also be separate. Again, there might be some community equitable liens that the court could consider, but that is generally how it works if you can show that, if you can trace that. So gifts, bequests, so that's inheritances, and again, the rents issues and profits thereof. So if there has been really good bookkeeping, really separate bookkeeping, that may be easy to show. But if not, it might be hard to overcome that presumption. Okay, and again, title or account structure alone does not defeat that community property presumption. That's because we've moved away from the Creasman presumption, and that got carried over into the committed intimate relationship realm as well. So if, and Walsh versus Reynolds gave an example of a unilateral control of earnings or paying a partner a salary for household services. Again, a live-in maid, a live-in cook, a live-in nanny, if that really is the relationship, that it's transactional, that it's not about creating a shared life together in any sort of romantic or marital-like setting, that is not a committed intimate relationship. So in terms of defending, especially if you are attempting to show that it was a separate asset because of the character of the funds that were used to acquire it, really good record keeping needs to be shown as well as in terms of purchasing real property, what the source of the down payment was, how that property was purchased, and whether or not the accounts were kept and maintained as separate. All right, so the Walsh versus Reynolds saga. This is an interesting case because It involved a 22-year same-sex relationship. It started in 1988. These were registered partners, domestic partners in California, and then in Washington, they became registered domestic partners. And then they separated 7 months later. There was $2 million plus in assets. So there were multiple trials, multiple appeals, and this all spanned more than a decade. But one of the things that the Walsh versus Reynolds saga shows is that the committed intimate relationship does and can survive even if there was a later solemnization of that marriage, that the parties were married later, or in the case of the former registered domestic partnership, that 2014 conversion to a marriage. The fact that they later married does not preclude the court from considering that premarital committed intimate relationship property and debt. And that is where a lot of the cases focus in terms of trials. You always want to look at whether or not there is a reason to argue for a committed intimate relationship or whether that's a danger and how to defend against that. And in the case of Walsh versus Reynolds, again, whether or not there's pooling of resources, that is not determinative. It can be really good evidence, but it does not actually win or lose the case in and of itself. And so separate finances kept in one party's name alone and paying a partner a salary for housework was not itself clear and convincing evidence of a separate property agreement. So these cases, again, are really fact specific, and the exchange of money alone or the separation of money alone is not necessarily going to win or lose your case. Okay. Oh, do we have a question? I can't hear you. Um, Amy, I still can't hear you. You're muted.
Apologies.
Okay.
It says, perhaps addressed later. Do you have advice for people who want to avoid CIRs/marriage? Is there a pre-cohabitation agreement? I don't want to help people hurt each other by taking all the benefits and none of the downsides. But for instances, I have older folks who want the companionship but want to ensure their estate goes to their family.
Yes. So I would recommend that you draft up or encourage a basically a cohabitation agreement to specify what is separate and whether or not there is any community interest created, because that really clarifies things later on for the family, because that has come up in litigation, that a long-term partner will assert a committed intimate relationship claim. And I think having that agreement spelled out to either acknowledge that or to dispense with that, I think is going to be really important. You could also do that and make and reference as well the estate planning pieces for that. If there is no will at all, that's where the real problem can be, right? Someone can have a long-term, decades-long relationship, even have business interests with their partner, and that former partner can insert themselves into the probate litigation or can file an after-death committed intimate relationship action to establish what the community portion is. And that, can be a big headache. So for estate planning purposes, I think that's a useful tool in addition to the testamentary documents, in addition to the will and any sort of bequest made in the wills, having a lot of clarity contractually via a cohabitation agreement is going to be important. And it's kind of funny because, in terms of attorneys, we're telling people to make all these things into contracts. And I think our clients or the general public views that as, oh, that's getting in the way of love. But really the best thing that you can do is to make sure that your partner and their family, that nobody has these questions arise after. And so that is a very loving thing to do. Same reason why we advise for prenups. You want to have those agreements worked out while the relationship is healthy and while both people are alive. I think that answers the question. Is there any follow-up from that, Amy?
Actually, it's a separate question.
Okay.
Domestic partners need to be registered in each state they live. If they are registered in California, will Washington honor the registration in California? Do they need to register in Washington again?
So under Washington law, again, the registered domestic partnership is only available when one spouse is over 62. And so if they're eligible for that, I would recommend that they consider that option if that makes sense for them. But I think it's more that Washington would see a registered domestic partnership from another state as an indication of a committed marital-like relationship, particularly given the history of what registered domestic partnership meant in Washington state. Before there was marriage equality, the registered domestic partnership statute, there were two versions. The first version that was rolled out, I 2007. I could be wrong about that year, but initially it gave some of the rights to same-sex couples that married people would enjoy, and in those days it was opposite-sex married people. And then it became the Everything But Marriage Bill. And then, of course, we passed marriage equality in the states. So, looking at that in terms of what a registered domestic partnership meant historically, I think that's really strong evidence of a marital-like relationship, because when that was the only tool available, that's what those couples did to really ensure that their marriages, or sorry, that their relationships were recognized and protected. So I believe that that's how the court would see RDP from a different state. But yes, if they're eligible in Washington for that would give them some protections. It's not all of the protections of a marriage, which of course is one of the problems and one of the reasons for passing marriage equality. Okay.
Okay, while I have
Um,
you and you're not on to the next subject, one more question.
sure.
You might have answered this, but I have had cases where they lived together for 20 or 30 years and one partner paid cash for everything. Mortgage, one half payment gave the other cash. Hard to prove when the one partner paid 50% for everything in cash.
So again, so okay. So in that case, yes, that is hard to prove. But I think the argument there would be that there was pooling of resources. It's just that these were cash transactions. And in terms of how to prove that, you can prove that with testimony. If you can show regular cash withdrawals around specific payments or purchases, or, these days a lot of folks use electronic cash transfers. That could be how you could show that the finances were pulled, or simply by demonstrating that without the support of the partner, that they wouldn't be able to cover all of their expenses, that the pooling of resources had to happen because of just how much the bills were. That would be another potential approach to that. Okay. So I'm going to finish up on this slide and move us along here, although this is more or less just a restatement of some of those earlier slides. I do think it's important to see this all in order here, because of course, Kelly, there was a statute of limitations that was missed, and again, how the court knew that the relationship was over and the statute of limitations was up. Was because there was only sporadic returning to the residence and the parties did not do anything social together. In Connell, and I've raised Connell and other issues where we've had inheritances, for example, to show no, that property was acquired entirely from separate funds. So even if there was a committed intimate relationship, that particular piece of property is not available before the court. Meriden versus Rettel, very interesting case, local Pierce County case, local marijuana business case, and is now built into our pattern forms for a petition for dissolution. Again, the lack of sexual intimacy, other sexual partners did not defeat the committed intimate relationship there. The former spouse was entitled to the community share portion of the marijuana business, which, was at one point quite profitable. So GFW has to do with that. When is it over? And the evidence about an unequivocal desire to end it. So um, if there was when there was a clear discussion about the end of the relationship, even if the parties continued living together, that would toll the stat or that would begin the statute of limitations. So there is an unpublished case that I came across distinguishing GFW, which was mostly about the credibility of one of the partners regarding the unequivocal end of the relationship. So essentially, the court found that one of the partners, was not credible that the relationship had ended. The court found that there were efforts to rebuild the relationship after that, and that the partner's testimony simply was not credible. Okay, so we've touched on this a little bit, what the CIR claimant cannot get. So the other partner's separate property. That's different than a marriage, and that would be one of the reasons, I suppose, to argue for or against getting married. For is if there's a lot of separate property, then having a marriage would actually allow a litigant to argue that the court should invade some of that separate property, but they can't do that in a committed intimate relationship. They also can't get spousal maintenance. They can't get attorney fees. There is no, well, you can establish what the community property is for purposes of probate litigation, but a surviving committed intimate relationship partner is not statutorily a surviving spouse or an heir. So in terms of the cost benefit conversations with the clients, and the fact that you can't get attorney fees, you are really looking at what is on the table as far as whether or not to even bring this claim, or maybe you don't want to bring the claim, and there's reasons to simply do a partition. Okay, so I want to move us along here. We talked about the scope of property as well. And in terms of the estate of Franks, again, the rents, issues, and profits from that separate property is also not before the court. So we can't ask for equitable distribution of the other partner's separate property, and that's been clarified by the courts. Okay, so the doctrine does survive death, and that was one of the earlier questions. That's the Oliver versus Fowler case. There was an accident, and the couple had died, and the court found that there was a committed intimate relationship. And so the surviving partner takes nothing by intestacy, the committed intimate relationship claim can deal with the decedent's share of the relationship acquired property. So again, that property that was acquired during the course of the committed intimate relationship. Let's see. And then in terms of the competing presumptions, joint ownership of the committed intimate relationship property is the presumption. And that can contrast the presumed correctness of the personal representative's inventory. Again, the court needs to also evaluate that competing committed intimate relationship claim. But separate property is off the table even at death. All right, and then that leads us into partition action. So this is a statutory creature. It's under RCW 7.52.010. So if several persons hold and are in possession of a real property as tenants in common, and there is no committed intimate relationship, or if you're past the statute of limitations or if for whatever reason that doesn't make sense for your client, you can still divide property via partition. And what the court will usually do is order the sale and determine the respective rights of the parties. So often that's specific mortgage payments, specific traceable contributions towards repairs and things like that. And if the court really can't figure it out, they might opt for a 50-50, but that's where evidence and bank statements and evidence of payments are going to come into play. It can get really complicated though. Not everybody has records. Mortgage companies change frequently as the mortgage is sold between businesses, and sometimes the records simply don't stretch that long. I did have a case where I was able to find some records, but not complete records. And we offered an extrapolation to show, well, over time, the available evidence suggests that this was the contribution of the various tenants in common. In that particular case, it was one where the statute of limitations had simply lapsed before lawyers got involved in that case. All right. And then traditional partition metrics. Okay. So physical division, most of the cases, all of the cases that I've seen, that's not a possibility. So if you can show that physical division shows great prejudice to the owners, in other words, you're not going to take a chainsaw and carve the house right down in the middle, the court can order the sale of that. And there's a statutory default for sale being by auction, but the court can also appoint referees or special masters is the common terminology if there's a lack of cooperation between the parties in selling. So partition cases tend to be one on showing the contribution of each co-tenant. So again, that's the mortgage payments and interest, taxes, repairs. Offsets could be rents collected from third parties, and the rental value of the exclusive occupancy after the ouster of a party can also be an offset. So after one person has left, they're presumably no longer contributing to that asset, and that would be taken into account in a partition action. Credits for improvements are measured by the value added to the property, not the cost incurred. That's actually a common issue and a common misconception with clients that they should get a dollar for dollar credit for what they put into the property. Residential appraisers will tell you that that doesn't necessarily increase the value of the property dollar for dollar. So there needs to be evidence, and that needs to be pled as well. All right. So this is a new law as of 2023, the Uniform Partition of Heirs Property Act. And it's the first major change to Washington partition actions since 1877. It applies to partition actions filed on or after that date, and the court will screen to determine whether the property is heirs property. So that is real property held in tenancy in common with no binding partition agreement. So again, in terms of how to work this all out, partition agreements are one way to do it with heirs. The co-tenancy or cohabitancy contracts really function similarly to a prenuptial agreement. And in this case, you can also have a contract for how the property is to be divided between heirs. So you can set that out. I highly recommend doing that because that avoids litigation. And but otherwise, Chapter 7.54 will control. And it can matter if a client inherited property with siblings and then later occupied it with a partner. So you can sometimes have both the uniform property division for heirs intervene or intermingle with a CIR claim. All right. In terms of the mechanics of that, the court needs to determine the fair market value of the property. And often that's by a court-ordered independent appraisal, unless the co-tenants can agree on a value or a method. Again, if that can be worked out either by contract or just by agreement later on, that would the valuation needs to be determined. And if there's not a sale, if some of the co-tenants do not want a sale, they get the first opportunity to buy out at the appraised value, the interest of those who do want a sale. Partition in kind is favored. So if there's not a complete buyout, the court could consider a physical division. But again, that would have to make sense. And if you have to take out a chainsaw, that's not going to happen. Um, Open market sale, not option, would be the method to go if the sale is required. The broker would list the property at the court determined value. Again, that's done by an appraisal. And then sealed bids or auction is only as a last resort. In terms of the practice pointer, there's not the leverage of a forced auction. There's longer times. There's potential valuation fights. Appraisal valuation fights are interesting. The issue in terms of valuation is going to be usually where the fights are about the contributions to the property, and then also, so for example, repairs, whether there should be dollar for dollar, how that impacted, what the comparables are like. I've seen also the value of the property get challenged based on they didn't use the right geographic area, or they didn't look at the right comparables in terms of the quality of the property, or the bed bath count even is off. So it's hard to know what you're looking for if you're not really used to reading appraisals. But if something seems off, then definitely consider a second opinion there. Okay, so writs of replevin. This is a fun one. So again, these are about love's leftovers or things that weren't previously divided. And if a committed intimate relationship division is not possible, or if you're past the statute of limitations, replevin is going to get at personal property. And that could be money, that could be vehicles, and the chapter allows for recovery of specific personal property, plus damages for the detention. Actually, because at least for the moment, pets are considered property. That could also be about getting the dog or the cat or the whatever the pet is back. So there would need to be you would need to prove the right of possession. There's a show cause hearing and oftentimes a bond required. So if there are identifiable items and there's proof of the right to possession, then if there's not a committed intimate relationship case, replevin would be your method. So sorry about the issues on the font here. But here on the right side is what the replevin action requires for proof that the plaintiff is the owner of the property, or is lawfully entitled to possession of property by virtue of a special property interest, including a security interest that specifically describes the property and interest. This could be a contract. In the case of pets, that gets really interesting in terms of proof. So who registered the pet? Who took the pet to the vet, who the vet had listed as the owner, who signed the adoption contract. All of these things could be indicia of ownership. And then in terms of, so the second factor, that the property is wrongfully detained by the defendant. So the plaintiff owns the property, the defendant's just not giving it back. And then the third factor, the property has not been taken for a tax assessment or fine pursuant to statute and has not been seized. So it has to be available to be awarded, essentially. And then the approximate value of the property also needs to be pled. And the burden of proof is on the plaintiff, and the standard of proof is the preponderance of the evidence statute. So the plaintiff, ultimately, it's about the strength of the title or right to the property, and the plaintiff needs to prevail on that basis, regardless of the defendant's title or right to possession. Okay. So in terms of the pleading strategy goes, you can always add on relief in the alternative. or you can consider that as a later action, or if the committed intimate relationship doesn't work. I'm curious to know how folks see pleading in the alternative, because I've seen it go both ways. I've seen it go as well. Your initial claim is so weak that, of course, you had to plead it in the alternative. Again, though, on the flip side, it can preserve your right to relief. And so you can, each case is going to be different. You do want to make sure that you're protecting your client's interests, and and you're also evaluating their risk exposure in terms of debt. You're also evaluating whether or not it's going to be worth it for them. So depending on the value of the asset, if they can't get attorney fees, do they still want to plead a committed intimate relationship? Sometimes yes, especially when houses are involved. That's where the majority of the litigation focus is here. So partition would fit if the parties hold joint title, but the relationship proof is weak, or the statute of limitations period has run, or your client is the titled partner and is resisting the quasi-community characterization. In other words, it makes more sense to say, well, my partner did not contribute anything, or contributed maybe 10% of the costs of this house. So, 10% is better for that partner than 50%. So that may be where partition would be a good remedy. And of course, it's a fallback remedy as well. If your client comes to you and it's been 5 years since the relationship is over, well, they've missed the statute of limitations. Statute of limitations arguments are a good way to end a committed intimate relationship on a summary judgment basis, because the calendar is pretty clear. If the evidence about when the relationship ended is also clear, or is not subject to a reasonable dispute, then that would be a good way to end the litigation without a trial. And if property is undisposed of in a prior action, you can go the route of vacating, or you can go the route of partition, depending on how long it's been, and depending on other factors as well, like how the property is titled. And so replevin is also available as personal property. Touching briefly on the motion to vacate, and in terms of other defenses post-decree, I always think that these cases are fascinating for CR 60 motions to vacate judgments. In terms of, so they have also a built-in statute of limitations for motions to vacate. And if you're operating under CR 60, I believe it's the Scrivener's error, there is no limitation on that type of correction to a decree. And there you might be talking about an omitted asset. For example, I had a fairly recent case where a partial motion to vacate on a Scrivener's error was proven because the listing of property, the asset and debts, which was incorporated as an attachment, was left out of an amended decree. So it made sense to reincorporate that into the decree through a partial motion to vacate. If there is a math error, a glaring math error, that's a good example of a motion to vacate under a Scrivener's error. Otherwise, though, you're looking at CR 60 B2, I believe, which is the 1-year statute of limitations on bringing those claims, things like mistake, uh, improper process, those types of reasons to vacate a decree need to be case specific and need to be properly pled. But there is a case that I found, it was unpublished, but it was after 2014, that stated that unilateral mistake was the basis was a proper basis for a motion to vacate, as long as it's promptly brought within a year. So the court can correct decrees, for example, a decree for committed intimate relationship, or if it's a decree of dissolution, but part of the issue was a committed intimate relationship, and there was some problem, some mistake or misunderstanding in terms of the overall value. Well, that can be undone with a motion to vacate as long as you're acting under the proper basis. So there are other equitable factors that can come into play if you've exceeded the 1 year statute of limitations and there's no Scrivener's error. There's still a catch-all under B11, which is really a need to vacate the order because it is unjust. That is a difficult thing to prove, particularly if a long time has passed. I think at that point, defenses of latches, someone sat on their rights. They knew or should have known about the problem or the undistributed asset and chose to not act. That could be a defense to a motion to vacate under CR 60B11. And then impossibility, if the property has been sold, if the assets have been spent, that would be a good defense as well. Okay. So I am a big fan of looking for committed intimate relationships, at least as part of the analysis, even for a dissolution, or if someone's coming to you for a parenting plan, but there's also property issues on the table. Clients don't always know their rights. And so I often see people that will assume, well, the house is titled in their name. I don't get any piece of it. Well, if you can prove that you were in a committed intimate relationship, you actually potentially do. And there's a similar issue too with de facto parentage, for example. People will say, well, I'm not on the child's birth certificate, even though I raised the child for 10, 12 years. Well, you might actually have parental rights. So be sure to ask those questions to really determine whether or not you can plead a committed intimate relationship. And then if you've missed the boat on the statute of limitations, or if there's some problem, let's say there was no holding out. Let's say they, told all of their friends and relatives in the community at large that this was a casual roommate situation. Well, you might still be able to get some relief under a partition action. And then that could benefit your client if your client was the one paying the majority of the expenses for the mortgage, for example, or the taxes. Okay, and again, consider summary judgment if it's clear that the house, for example, was an inheritance or acquired by inheritance, or the statute of limitations has been missed, because that would be a good way to resolve the litigation without having to go all the way through a trial. And again, consider a motion to vacate, because if the decree needs to be corrected for whatever reason, you want to see if you're acting within a year and what the reason that the property was omitted was. Was it mistake? Was there some error in process? Was there some fraud? Was it simply undisclosed, which is akin to fraud. Okay, preventative lawyering, cohabitation agreements. We've already talked about this a little bit, but you can contract around the committed intimate relationship doctrine just as you can contract around normal community property presumptions with a prenuptial agreement. So you can fix the property rights by agreement. And again, in some ways, this is actually pretty romantic because you're protecting your partner. You draft it like a prenup, full financial disclosures. It has to be voluntary. It has to be substantively fair. I do recommend independent counsel for each party, or at least advising the client not the client, but advising the other party very clearly of their right to have it reviewed by independent counsel, and make sure that it's the circumstances around the drafting of this are free of duress, that there's not some sort of threat or improper promise attached to this, that both parties speak English, that both parties have a chance to review it. Those are similar to defeating a prenup. You want to make sure that you're above board and that it's drafted properly. it's good to address in these types of agreements the characterization of both the income and the acquisitions during the cohabitation, whether anything was brought into the relationship, how title is going to work, how contributions are going to be assessed, buyout and sale mechanics at separation. Again, if you can work this out by contract, the contract is going to be enforced in any sort of committed intimate property distribution, assuming it's fair and assuming that it was done properly and addresses everything properly. So again, a modest flat fee today versus committed intimate relationship in the future with, again, no ability per statute to recover those attorney fees, it's going to be worth it to protect the property interests. Okay, so I wanted to open it up to questions. I'm not sure if there are any, Amy, maybe you can let me know, or if people can unmute and just want to ask their questions or even share their stories. I'm a big believer in collective wisdom.
So what I've done is I've allowed everyone to speak. They just have to unmute themselves. And
Okay.
we have not had any new questions yet. However, I did want to mention that regarding the discussion on contracts,
Yes.
Washington Law Help does have a really decent write-up on living together contracts. So that's available if people just want to say, hey, you can always check out Washington Law Help if you want a little bit more information.
Yeah. Thanks. I love it. It's interesting how much of the committed intimate relationship case law and how much of the de facto case law is driven by folks in same-sex relationships and kind of that history. And of course, the resulting holdings and rulings and fact patterns are available to couples of, opposite sex as well. I think it's important to look at the doctrinal underpinnings of that and really understand that this is something that really benefits everybody, but kind of the pioneers of it were folks that weren't able to access marriage. And in the case of the reason for that 62 or older still being part of the registered domestic partnership umbrella is because there are significant benefits that can be lost. For example, Social Security benefits or other types of benefits if there is a marriage. So those folks can still have access to registered domestic partnership registry, but only those folks. And then, of course, my personal views on that are my own. They're not the law library's views. But I do find it fascinating that that we had some pioneers for quasi-community property because of being denied access to the statutes for many years, many decades. Are there any other questions about how this can play out, or does anyone want to share any stories? I think I mentioned the hubby email in one of my cases. And another one of my cases, this was a dissolution of marriage, but the house had been acquired before marriage. And in that case, I had 5 minutes with a witness because of the judge controlling the trial, but I was able to establish in those 5 minutes that the witness had no idea that the couple was together as a couple when the house was acquired. So that was a pretty interesting case as well, and that really set the stage. I did say I want to leave space for questions, but I wanted to talk about the community lien and how that can play out if there's no other questions.
There is a question that just
Okay.
popped up. It said, did you discuss attorney's fees in a CIR?
We did, and because it's not a creature of statute, it's not under the 2609 umbrella. So RCW 2609, either 140 or 040, sorry, it's not coming immediately, deals with provisions that are brought or defended under that 2609 chapter. And so because of that, committed intimate relationships aren't under that chapter. Now, attorney fees can also be awarded by way of sanctions, CR 11. um, contempt, but not the way that we do that under marriage. Now, if it's a kind of a mixed fact pattern, so it's committed intimate relationship that then became a marriage, while all of a sudden, separate property is open for distribution, potentially under the marital framework, and attorney fees are also possible under the marital framework. Um, but in terms of the characterization of the property, separate or community, that is established when it was acquired. So, for example, in the case where the community did not know that this was a committed intimate couple because it was too volatile, because they broke up, because they weren't living together, because they were on and off again, whatever the issue was for the stability of that relationship, if that property, in that case, a house, was acquired before the committed intimate relationship, then it's going to be separate and not divisible under that theory. But then, of course, the court needs to look at whether there's a community lien, particularly if the couple then moved into what would have been the separate house, and then began a committed intimate relationship. So that question is also really interesting because it's not just a matter of how many of the community's dollars went into the asset. It's also a question of whether or not an adjustment or lien is due. So in that particular case, and in other cases since that trial, I have looked at the question of what's the fair market rent compared to what the mortgage was, and also what were the uses of the property. If the community got way more out of the property than they put into it as a community, then no lien is due. And that's generally how the courts analyze it as well. But you need the evidence for that to be able to present. Amy, were there any other questions?
Miss Allen,
I'm
actually,
so sorry. Please do.
my name's Todd Howard, and I have a question with regard to the cohabitation agreements, because it seems to me that you could, contract around or lay out, hey, this is our separate property as we move in together, and we're coming up with this agreement. But if you're together for an extensive period of time and you acquire property during that, that time, I know it seems I don't know how you get around that being characterized as community, subject to some sort of division. The separate property you bring into the relationship is off the table, but while you're in the relationship, and potentially acquiring, and for example, let's say a longtime a Boeing employee gets in a relationship and they've got union benefits that accrue and pension stuff that accrue and all that kind of stuff. And although they may have a cohabitation agreement, that stuff that gets accrued during the relationship, is that not subject to maybe division?
So I think that's a good question. Thank you, Todd. I think the court would look at that similar to how they view prenuptial agreements. So, for example, a prenuptial agreement that expressly disallowed any contribution, or sorry, any acquisition of community property, and protected all community property, what would be community property, from distribution. That has that the court has in similar cases struck down those prenuptial agreements. And I'm thinking of I don't have the case citation by name, but it was a scenario where the wife coming into the marriage had next to no separate assets, and the prenuptial agreement was something along the lines of, well, we're, anything from the husband's business was going to be his separate property under that agreement. Well, when that marriage broke down, that was really all there was the profits of this business that had been separate, but would have been characterized as community in the absence of that agreement. So I think when it comes to enforcing those agreements, if it's too lopsided, then I think it can also, just as prenuptial agreements can be stricken down, I think it can be stricken down. So I think In terms of the full disclosures and in terms of the overall fairness of the distribution and the circumstances around the drafting of the cohabitation agreement, would be very key points to plead. And then, of course, it needs to have some sense of fairness, and each party to that agreement should be given the opportunity to have that discussion with a lawyer, and ideally should have a review by a lawyer just to test the fairness of it, to avoid a very one-sided result, because it is an equitable doctrine, so it needs to be fair at the end of the day.
I have another question real fast. For the purposes of the statute of limitations, how do you determine the end of the CIR? Is it the last time the couple cohabitated, last time they held themselves out as a couple? Does it matter if there's an occasional time when the couple gets back together briefly after no longer cohabitating?
That's where the litigation is. Just as in divorce cases, the court has discretion, and the result would be evaluated for an abuse of discretion. So the case law says an unequivocal rather intention to end the relationship. So it's done. But then there are questions of credibility. And is there evidence that they were still working on the relationship? In terms of the case law there, if there's evidence that they're still working on the relationship and that they still kind of consider themselves a couple and operated as a couple, even if they're not full time together. And that's the saga that I mentioned. But yeah, it's very fact specific. So you're going to want to plead that if you're trying to convince the court of the end date for the statute of limitations, but it will ultimately depend on the evidence and the credibility of the parties in terms of, was the marriage over or not. Simply maintaining two residences would not necessarily defeat the marriage if there was, the committed intimate relationship, if there was other evidence that supported that it's still ongoing. So multiple residences, trips back and forth. But again, if the court believes that there was an unequivocal intention to end it that was clearly communicated, then it's over. So yeah, that's where the litigation is really, and where the evidence and the credibility is. Go either way.
Okay. I have a comment. I don't believe this is a question. It says public policy prefers marriage, so I am surprised that prehabitation agreements are enforceable.
Well, they are. Again, they're evaluated really the same way that prenuptial agreements are, and they should be drafted the same, with the same care and standards.
Okay, we are actually out of time for today. So Beverly, thank you so much. Really amazing information. And I have been recording this CLE, so it will be available if folks want to watch it again with the materials. If anybody is missing anything, let me know right away, and I'm happy to send it to you.
And then if anybody has any questions about this CLE, or just, wants to network, my business is Nexus Legal Counsel. My email is Beverly, that's my first name, @nexuscounsel.law. And thank you all for attending.
Thank you all. I'll be sending out evaluations. Please fill them out and send them back, because it helps me make sure that I'm providing CLEs that are helpful. And hold on, we just had one more thing. Oh, it says, yes, thank you. And thank you. And you did a great job. So
All right.
love
Thank
that.
you, everyone.
Thank you, everyone. Bye-bye.